Welcome to Dad Talk Today. My name is Eric Carroll, and we have an amazing show lined up for you. We are fighting for fathers all across the United States and all across the world where you can be glad to be dad. Stick around, guys. Dad Talk Today is about to begin. Hey everybody, welcome to Dad Talk Today. It is a Monday night. We got our live Q&A coming on tonight. It has we're in a new year, and I'm here with Kevin Hickey. Kevin, how you doing, man?
Good. It seems like it's been a year since I've seen you, man.
It has. Yeah, it definitely has. Tell us, man, how was your holidays?
It was great. We stayed home. We had planned to travel the last week and decided against it because of all the airline problems, and we just didn't want to have to deal with the stress. So we stayed home. We had a good holiday. How about you?
It was all right. I think we went and watched Ghostbusters Afterlife for New Year's, which is an amazing movie. If nobody saw it, I won't spoil it for you, but you definitely need to go and check that out. But, you know, one thing, if you're inside this community, sometimes I think the holidays is one of those things you want to get over. So I'm hoping anybody that's watching this tonight that everything went well with you and that you had a good holiday. If you got some questions for Kevin, put it down in the comments. Nothing about this creates a client-attorney relationship. But if you got some questions, put it down in the comments and we'll get to it. But before we get there, we usually talk about a subject before we get into taking the questions. Kevin, you got anything you would like to touch on tonight?
I do. Before I get to that, your holiday comment kind of made me think of something. We, Monday after the first of the year, we're back in the office. It's open, and of course, we're starting to get the inevitable emails from clients, calls from clients about different things that happened during the holidays. And I had our staff check in with a few clients that had some issues leading up to Christmas. To check in on them, see how things went, if they got their visitation, if they didn't, what happened. And so we're kind of in that phase of maybe having to file some motions with the court to correct some of that stuff or get some time back that may have been lost. So if you're out there and you have a case going on and you had some issues during the holidays with visitation, call your attorney. It may be time to start moving on that so you can try to get some of that time back in the future. But one of the things I wanted to talk about is settlement. A lot of times when you get in a case, and a case is a living being, it's not something that's black and white. It's not something that stays the same. And your attorney's opinion of your case may change as you go through the discovery phase, as you get closer to trial. And there's a lot of reasons for that. And I think a lot of clients across the country will get a little bit disillusioned with the practice of law. And one of the reasons, or their attorney, one of the reasons for that is they wonder why their lawyer's opinion of their case has changed. And a lot of it is because of the discovery that we go through, the evidence that we find out. When you come in and tell me your story, I'm always very cognizant of the fact that I'm getting your side of the story. I'm not saying you're lying or embellishing or not telling me the truth. It's just that, the vast majority of the time, I don't know you, you don't know me, and I'm hearing your story for the first time. So I've got to really listen to all of that, take what you're telling me seriously. But I also have to understand that there's going to be a whole different story being told to the other attorney. And a lot of times the truth is sometimes in between, and a lot of times the truth is right there with the client that's sitting with me. So, my job is to try to figure out exactly what's going on in your case and try to look at it from the standpoint of what a judge is going to look at your case like, because that's who's going to be ultimately determining your case. What's an ad litem that gets appointed that comes in to represent the children and is neutral, supposed to be neutral? How are they going to look at the case? So I'm trying to be as objective as I can, understanding that I'm going to be your advocate, listening to this story that's happened to you that you've lived, and figure out what the best course of action for you is. And I will have an opinion about your case based on what you've told me from the very beginning, but that again may change as we go through the case. So a lot of times, as we begin discovery, we'll start to get witnesses, different witnesses that are going to come forward for you, witnesses that are going to come forward for the other side. We get evidence. These days, the last several years, it seems like digital evidence is some of the biggest evidence we have. Facebook posts, Instagram posts, text messages, emails. We get a lot of that. And we get it from the other side. You're going to provide me as the client, you're going to provide me with a lot of the evidence you have, and then the other side's going to provide me with a lot of evidence too. We're going to do our due diligence and try to see what they've got. 50, 60 years ago, there were no discovery rules. It was just kind of what they called the Perry Mason moment. You would go to court. That's when you saw what everybody had evidence-wise, and you figured it out. And the Supreme Court and the Bar Association came along and said, look, we need to do some discovery because we think we can avoid a lot of trials. We can encourage people to settle. If you show us yours, we'll show you what we've got, and let's see if we can settle these cases. So the discovery rules came in place, and they work. And once we see what the other evidence is on the other side, I may say, look, I thought they were going to have a strong case, but they don't. Let's try to push for a hearing, or let's try to offer something that really gets you what you want in a settlement. Other times they may send us all this evidence, and I may say, hey, we've got a problem here. We've got some pretty good evidence, but what they've got over there is substantial. And that's something that's going to be very hard for us to overcome. So evidence is one reason you may want to look at a settlement. When I'm considering a settlement, I'm always thinking about the judge we have. What has this judge done in the past? How have they handled certain issues? Are they a joint custody judge? Are they a judge that's going to be really mad at dad for sending whatever texts were sent? Are they a judge that has a history of really coming down on mothers that keep children away from their fathers? Those things are in my mind when I'm trying to decide if we should settle your case or not instead of going to a hearing. We look at the law. Who does the law favor on some of the issues we have? Some of the evidence rules. Are there things we're going to be able to get into evidence? Other things that I'd really like to use, but I can't get into evidence. You've sent me a really good letter from a doctor out of the state of Washington, but we're in court in Arkansas. Is that doctor going to come in and testify? Are you going to pay the $5,000 retainer to have him testify? If you're not, we may not be able to get that evidence into the hearing at the trial. So all of those things are factors that we take into consideration when we're trying to decide whether to settle your case. And the reason I'm taking a few minutes to tell you about this is because over 90% of cases settle. So I would be shocked if at any point in your case that your attorney doesn't approach you and say, is there some kind of settlement offer you'd want to make? Or your attorney calls you and says, hey, we've just received a settlement offer from the other side. A lot of people look at that as giving in, or if we make a settlement offer, they're going to think we're caving. That is not the case. You need to listen to your attorney, and if they think there's a place to settle or that you should make some kind of offer, you need to listen to them. Now, remember what we always say, the attorney works for you. It's not the other way around. They work for you. So you go set up an appointment if you want to. Ask them any question you want as to why you're settling. Why do you think this way? Why do you think that way? And get comfortable with it. But find out all the information you can as to why your attorney may be wanting to make a settlement offer. And finally, always remember any settlement is up to you. The attorney can't settle a case on his or her own without you. You have the final say so whether you sign that agreement or not. And if you don't want to agree, or there's a part of a settlement you don't want to agree to, you're going to either need to tweak it with your attorney, or you're just you don't have to sign.
Yeah, definitely. One of the arguments I think I've heard in the past is like the attorneys will promise the moon and stars, and then after they get there and spent most of the money, they'll say, oh, you're not going to get what you want. You need to make a settlement. Would you say that the red flags really need to be somebody that's promising anything before they've seen the full case play out?
Yes, yes. And I am notoriously maybe negative, or I like to use the word conservative with clients when they first start. I will never guarantee anything. I will never say you have a slam dunk case. It's just not in my vocabulary, because I've been doing this long enough to know that a case, like I said, it's a living thing. When you come to see me, you may feel like it's black and white what this person's done to me, and I need Kevin's help, and we're going to win, and that's the way it's going to be. It's a living thing that's going to change as we go through the case, because I've got to learn what the other side has, what evidence they have. And I get real leery of attorneys that promise those things right out of the gate, because it's just not, that's not the practice of law. And, you know, and I have clients that say, well, I've got an attorney that I talked to yesterday that quoted me less of a retainer than you have, and they promised me X, Y, and Z. And I said, well, you may want to go to that attorney then. Maybe they have some magic stuff that I don't have, but I'm just telling you, in my experience and how long I've been doing this, what I see and what I'm seeing right now. And yeah, I get real leery when an attorney right out of the gate is promising a lot of stuff.
Yeah. All right. Well, I'm going to get some of these questions. I appreciate you for going over that. That's definitely something we need to talk a little bit more about. Ronald McLaughlin here on Facebook said, how do I reduce the child support obligation that is extremely too much? $2,500 a month plus all the medical, dental, vision insurance. I am working a mission critical job serving our nation. I cannot get the 128 overnights to get shared physical custody in Maryland because I am working overnight. During this pandemic, I'm working 80, 90, 100 hours a week, and they have based the support of this unprecedented overtime.
Okay, Ron, a couple of things on this, and thanks for serving our country, by the way. And there is the Soldier and Sailor Relief Act that is out there. It's a federal law that every state has adopted. And it basically says that if you're overseas, there's a lot to it, so you'll want to check with the attorney in your area about it. But if you're overseas, you're deployed, whatever, someone can't just file a lawsuit against you and go forward unless you consent to that. Now, again, there's some subsections, subparagraphs to that and whatever, but you do have some rights being overseas to not have all this going on in the United States against you while you're halfway around the world. So you may want to check into that first. Also, I think you need to understand that child support's always modifiable. So if you feel like it can be modified in any way, you've had a reduction in income maybe, or something along those lines, you can have it reviewed. So you may want to get with an attorney about doing that. That's the biggest thing. And then on the custody, it sounds like you're supposed to get a certain amount of overnights per year in your custody order. You may want to get that modified as well. If you're going to be back soon, then you may want to leave it alone till you get back. But if there's time that you can get that time somewhere else, as opposed to what your current order is, you may want to try to get that modified or changed.
We got one from Craig Sosi. He said, what's the rights to a speedy trial?
Well, that's more of a criminal law question, and it goes to they have to bring you to trial within a certain amount of time. Usually it's 1 year after charging you with the crime. Now, there are exceptions to that. If you're the defendant and you ask for a continuance and it gets granted, a lot of times that extra time allowed until you get to trial is not counted. So your rights are that you are entitled, you have a right to be brought to trial within a certain amount of time, and I believe it's usually 1 year.
Cody Hill said, so my ex-fiance and I have a 2-year-old, and she uprooted everything and went to live with someone else with no license, no job. And I'm supposed to pay $1,000 a month in child support when he isn't even in daycare. I represent myself the first day and got every weekend with him, court order, temporary orders. We go to court in 2 weeks to sign everything again, but she claims she makes more than me. but she isn't employed and is making side money. I have my own house, own car, and full-time, good paying salary job, and I'm confused how she gets awarded primary.
Can you put that first part up again?
Yep.
Okay. Court order, temporary orders. We go to court in 2 weeks, sign everything. So, so his question is about she's now claiming, or she's claiming she makes more money, so he's wanting to modify that. Can you
That's
go
what
to
it
the
sounds
next part?
Yeah.
House. Well, you're saying confused how she gets awarded primary. It sounds like, Cody, that you're coming to an agreement with her on all of this. If you're not agreeing that she should be primary, then you may want to try to have a hearing on that. I don't know if you have an attorney or not. It's kind of sound like you might be pro se, but
he did say down here that my attorney never talks to me and says we have a case. I'm just confused.
Well, I think you may need to set up an appointment with your attorney and go in and sit down and ask some questions and just ask it. And this goes for anybody. If sometimes we get caught up because we talk to Brad Hull's a partner in my firm, and we talk and we use legal terms and all that. And sometimes we get caught up in that and then start talking with a client and forget that they don't know some of the mumbo jumbo words we're using. And we've got to talk like a normal, nice person for a little while. And, go in there and say, you say I have a case or I've got some good evidence. Why am I agreeing to her having primary then? Or why are we doing that? Ask it straightforward and get an answer. And there is an answer. I mean, there's an answer that your attorney thinks that way, and you're entitled to know. So I would tell you, it just sounds, I'm trying to get the sense of what's going on with your case. It sounds like you're coming to some kind of an agreement. And if you don't agree with it, then you may not want to agree to it, but you need to talk to your attorney and find out why you guys are doing that.
Yeah. Got a little bit of, I can tell this guy is frustrated and he's got his problems with the system. I want to bring this question up just so you can touch on it, Kevin. His name is Devon Ewing. He said, I don't believe many attorneys work for the client. They be friends with the judge, DA, and the other party's lawyer. It's all money, man. And the law simply need to be changed, period. Why are you attorneys helping push that is the question. I think grouping all attorneys in that same box is kind of a dangerous thing.
Well, that's what I'd say. And Devin, I mean, I can't speak for your experience. I don't know what you went through, if you had a bad experience with an attorney or more than one attorney. All I can tell you, and I want to tell this to everybody, the vast majority of attorneys out there, not the small majority or just over 50%, the vast majority of them want to do a good job. We know we went into the profession for a reason. There are ethics rules out there that we know we have to comply with as a profession. And we know that people are coming to us with some of the most important things in their lives and paying us very, very hard-earned money that they may have had to go to family members or more than one family member to collect enough to pay us to help them with their case. And the vast majority of attorneys take it seriously. I think there's a pretty large segment of people out there that feel differently, that think it's just some big racket and that all the attorneys are in cahoots together with the judges, with the DAs, and everybody's just doing a money grab. And I'm sorry, but that is just not the case. And I know it's hard to know that or have trust in that when you're not in that profession. But the vast majority of the attorneys we don't wake up in the morning and say, I hope I can get some suckers in the office today to pay me a lot of money and then just never see them again. It's just not that way. And that would be my answer.
And that's not to say that there isn't those guys out there, because I know plenty of them. I mean,
I said vast majority, not 100%. So every profession has bad apples. And, I really think, and I don't know because I'm in the profession, so I'm biased. I really think a lot of people hire or try to hire the very first lawyer they call. And I think that's a mistake. I think if you've got a case, if you're going to need a lawyer for something, that's an important decision. And I think it needs to be just like any other very important decision in your life that you're going to make. You need to take some time, interview 2 or 3 of them. Take your time and pick the right one. Don't just hire the first lawyer you call. And I even say that if I'm the first lawyer you call, you need to be comfortable with who you're choosing. And the first lawyer you call might be the worst. They might be the worst lawyer in your city. And that goes to something else. I think a lot of people think that lawyers are interchangeable and that their skill sets and skill levels are all the same, that you can get lawyer A or lawyer Z and they're going to be the same. And that is far from the truth. They are all very different in their experience, in their skills, how well they do in court. There are 100 different factors for a lawyer as to whether they're very good at what they do or not good at what they do. So do some research before you hire one.
Before we move on with that, though, Kevin, because there might be a lot of people that they're wanting to talk to more, but they don't really necessarily know the questions to ask to distinguish who they need to be picking. What would you say the top 3 questions to really find out who you're talking to, who's going to do a good job for you when you go in and you talk to that attorney for the first time? What would be the top 3 questions you would suggest somebody ask?
Well, one of the first things you can do that you couldn't do 20 years ago is Google avvo.com, avvo.com, reviews attorneys. Those are great starting points that will give you comments from clients many times, comments from other attorneys. So that's a good starting point. But when you go in to talk to the attorney, ask them. When you tell them what kind of case you have, ask them what percentage of your practice is handling these kinds of cases. 80 to 85% of my practice is divorce and custody. So that's what I would tell you if you asked me that. The second question is you want to know how often are they in court? If they do a lot of matrimonial law, divorce and custody, they should be in court a lot, or they should be litigating quite a bit, because that's often a very contested area. So you want an attorney that is comfortable going to court and is not leery of going to court. That's another misperception. I think the general public thinks that every attorney out there is very aggressive, very good in court, and just like what you see on Law and Order all the time. And that is not the case. There are a lot of attorneys that are terrible in court. It's just the way it is. So that's another question you want. How often do you go to court? Do you know the judges? And what I mean by that is not know them personally, so you're getting some kind of favors. How do you know the history of this judge? How do they treat particular legal questions? What do they do in a case like mine? Do they seem to have something to get against fathers or against mothers? How are the judges here, and what do they do? And how familiar are you with how they rule on those issues? And then finally, you always want to ask them about fees. Ask them about the retainer, how that works, and fees and how they bill. Those questions, if you ask those questions, are gonna get you a long way to figuring out.
Now, how important is that to know what kind of judge you're going to be in front of before choosing that attorney as well?
Well, you do want to know, and it's hard to figure this out unless you just talk with other attorneys, which you can do. It's hard to know. Judges are people too, and there's people they like and attorneys they like and attorneys that they don't. And that usually comes down to how the attorney acts in court. Are they trying to constantly get evidence into evidence that they know is not admissible? Are they not following the procedures of the court or the evidence rules? Judges get very frustrated with that. And so there's some attorneys that are constant offenders about that, and they get tired of it. And so, an attorney's not going to own up and say, well, they might say, old Judge so-and-so, I can't, they hate me or whatever. But you can ask that. Just ask them, do you have a good relationship with the judges, and are they okay with you being in court? Yeah. And hopefully they'll be upfront with you.
Chris Zedwajowski. He has told me how to say that before. I think I got it right. He said, why isn't custodial interference considered child abuse and domestic violence? Isolating a child or ex-intimate partner from family members is domestic violence defined in the domestic violence pamphlet provided to me from police.
That's a real good question, Chris, and we get it quite a bit. And I saw something today. I don't know where I saw it, but somebody posted something about parental alienation, basically custodial interference being a crime, and it is a crime in most states. I think it is child abuse. If especially if the child is put right in the middle and knows what's going on, and that they're supposed to go see dad and mom isn't allowing it, I think it is child abuse. It's very upsetting. That's a good point, Chris. And all I can tell you is I'm pretty sure it's a crime in all 50 states to interfere with someone's custody rights or visitation rights. And if it's something that's continuing to happen, go to the police or the prosecutor. And you may need to get an attorney too to try to do something through the domestic case. And that's something to keep in mind too. There's really two parts to that. It's a crime, which means you're going to need the prosecutor to get involved. So you go to the police, you make a police report about the custodial interference, and then they will usually take that to the prosecutor. The detective will. You'll want to follow up with them and make sure they've done that. And then the prosecutor will make a decision whether they're going to prosecute that person or not. It's just like what you've seen on Law and Order. They say the police that investigate the crimes and the prosecutors that prosecute the offenders. The prosecutors make that determination. So it's a crime. The second part of that is you may have a family court remedy, which is contempt. If you've got an order in place, which you must have since you've got this custody issue, if the other side violates that, they can be held in contempt of court. So you can go back to the family court and ask that judge to hold the person in contempt. They can be fined. They can be ordered to pay attorney's fees. The judges have a wide range of punishments that they can put on a parent that violates the order. So there's two different things you can go with there, and a lot of people go with both. They try to get the criminal case started and also go back to family court.
Yeah. Cody Hill said, best question to ask with the discovery.
Try to clarify that a little bit, Cody. I'm not sure what you're asking there.
Yeah, he's got another one right here. He said he did hire an attorney and gave her several texts and things to help with his case to fight for full custody. But how do you modify the child support and fight back to the case?
Well, child support is an income decision. So usually a lot of states do it differently. Arkansas, until last summer of 2020, only looked at the non-custodial parent's income. Now we look at both sides, and we have a formula we use and a worksheet we fill out to try to determine what the child support is. And I think a lot of states are going to something like that. So Cody, if you've got a child support amount that you think is wrong, you may want to have your attorney look at it and recalculate it for you and see if there's a change. I think that's what you're asking. As far as, I think you're going to say you gave her several text messages. We get that a lot, and that's what you're supposed to do. Give them to your attorney to use at your hearing.
Michelle Early Manor said, is moral turpitude a grounds for a father to get more custody? The mother used the child to help her shoplift and is awaiting trial. Already spent $14,000 in child custody. The mother, since we found out of charges, has withheld the child for 5 weeks now.
Absolutely. That would be an issue, Michelle, that I would definitely want to bring in front of the judge. Involving a child of any age in shoplifting, a parent absolutely should not be doing that. You're basically teaching the child to commit crimes. So that is something I'd want the judge to know. That may be even enough to ask for some kind of an emergency hearing. You just have to talk to your attorney about it. And that, combined with the mom withholding the child, you guys need to get on it somehow. She's at least in contempt. Will you have enough to change custody? I don't know, but she's at least in contempt, and you need to bring that in front of the judge.
Yeah, man, that's crazy because I just heard another person say the same exact thing, I think last week. They had a case almost exactly similar. That is nuts.
Oh yeah.
Mark Basler said, should I keep a daily logbook on visitation and other interactions? And is it admissible in court?
Yes and yes. So you absolutely should. And what I tell clients to do, Mark, is get a calendar, like a book type calendar, and that way you can write on the date. You're not having to keep a list of things, but you do it however, whatever's easiest for you, either a legal pad or whatever, but just make sure you have the date and the time and write down what happened. So if you were on time and she was late, write it down. If she was combative at a visitation exchange, anything that happens that you think will be helpful, write it down. It's much better to have too much stuff written down than not enough. Your attorney will go through all of your notes and your calendar and figure out what he needs to go to court with. Is it admissible in court? It can be. So, we have a discovery question in our interrogatories that we ask, and our request for production of documents that we send to the other side. When I was talking earlier about evidence, bringing your own evidence or having the other side have evidence, when we send those interrogatories and requests to the other side, we always ask, do you have any diaries, journals, calendars that you've been keeping notes in? Because we want to see it. So yes, keep that in mind. Write down what happened, but understand that any little comments you make or derogatory names you put in there or whatever, you don't want that coming out in front of the judge. So keep it, I guess I'd use the word professional and to the point as to what happened, and try not to put extraneous information on there because you don't want that to come up in front of the judge.
Jamie Donald said, do you as a lawyer believe laws need to change regarding fathers' rights? I believe it was you, Kevin, that actually testified on behalf of the shared parenting up in Arkansas, right?
I sent a letter down that was provided to the representatives and in support of our shared parenting law. Yes, Jamie, and I think the way to do that is shared parenting. I think that's where the wave across the country is headed, and it's headed that direction. So I think the momentum is there.
So we got a couple of questions about like, what would you do when it's talking about the system? I know shared parenting is something we've been advocating for ever since the show has been going, but what are some other tweaks that you think would really benefit the system if we could get those in place?
They came out with, I guess I'd say, gender neutral laws. They came out and said that you're not supposed to favor moms anymore, and it's both parents are equal and to be considered equal by the judges. That's been in place now. Once that was put in place years ago, I'm not sure that a lot of judges just changed their thinking on it. I think they'd been kind of hardwired to think about that moms are the nurturers and they're the ones that are usually home and taking care of the kids. So we kind of lean toward moms for custody. That was a big change. And I think with the shared parenting stuff that's coming along, that is helping change the thinking. And the reason I say all that, when you talk about tweaks, that's what it's going to take. The people making these decisions are judges, men and women that are sitting up there on the bench making these decisions. And I think we've got to keep changing that mindset that we say it, we give it lip service that fathers and moms are equal, but we've really got to start doing it, And other than that, I don't know how much other stuff you can get, because you start to run into constitutional issues too. You're not supposed to put into place statutes that favor one gender over another and that kind of thing. But I think the judge is getting more used to joint custody, and dads really being involved just as much is going to be what changes it.
Definitely. And I think it's a cultural problem too. Just one of the things I was talking to my wife about the other night. Have you seen the new season, or I don't know if you've watched the show at all, Cobra Kai?
No, but I hear about it. I keep wanting to see it.
Amazing. As I was sitting there watching it the other night, and you guys go back and check this out. Johnny, Daniel, Robbie, Miguel, even Robbie's girlfriend, all came from fatherless homes, had dads that weren't there. It's
Wow.
almost like everybody in the episode, and there's like this notion that dads are just these deadbeats that don't come off. And whether we see it or not, that plays back to the fatherless issue. It plays back to the image that people have in their heads when it comes to dads and being there and their importance and the parenting roles.
Mm-hmm. Yeah, that's true.
It really is. We got a question from Red NMF. He said, I have a question, just general. Isn't it considered double dipping when you take the entire earned for the year to cover child support, and then on top of that to be charged child care services? Where are you supposed to get the extra money from if they're already taking support off of you overall and not your guarantee?
You know, Eric, I think we had a question 2 or 3 weeks ago, and it was a little surprising to me. And now it's coming up again that someone's paying child support. Plus, it sounds like they're paying child care services. That, that's not supposed to happen. Now, maybe some states do that. I don't know. But I don't know where you're supposed to get all the extra money from. Red, it's supposed to be based on your income. You're not supposed to have to be paying 60, 70, 80% of your net take home pay just on support. It's just not supposed to be the way it's supposed to be done. You've got to be able to live too. So I don't know if you need to go back and have it modified or what, but that may be something to look at.
And that's not even including when you put in the conversation alimony. I mean, I've talked about this several times. I got a father here in the state of Georgia. I think it's supposed to be like 20% of your income with child support. Guy makes $250,000 a year after child support and alimony comes out of his paycheck. He's bringing home $25. And I mean, how can we expect people to live off of something like that? So I definitely understand what you're saying there, brother. Aaron Mendiola said, where can we get data on the percentage of fathers who pay child support over mothers who pay, or the percentage of who gets residential primary? You got any good places for that, Kevin?
I don't, Aaron. It's a very good question. I would bet that the child support enforcement agencies might have some kind of data like that. And a lot of times they share information from state to state. That's probably the place that would have it. Now, whether they would release it or not, I don't know, but that's the closest that I can think of. Otherwise, it's going to be very hard to gather that data. But the child support enforcement agencies of each state gather all kinds of data on their payors, and that's probably the best place to try to get it.
Aaron, I have seen those statistics many times and percentages. There might even be somebody here that can put it in the comments. What I would say to you is go to Google and put in percentage of fathers who pay child support over mothers who pay, and then a percentage of who gets residential primary. The percentage on residential primary, according to the U.S. Census Bureau, I want to say it was like back in 2013 was 82.5% of the time it goes with mom. But I have seen that on the child support. I think you can find that on a pretty simple Google search. If not, get back with me and we'll get that out there to you.
In 2013, I would not doubt that percentage on residential primary, 82% or so for the moms. I wouldn't doubt that.
It's still, I think it tweaked a little bit, went down a little bit, but it's still over 80%. So we're right there, 4 out of 5. So, HC9 here on YouTube says, question, how often have you actually seen a parent be held in contempt?
A lot. This goes back to what I was saying toward the beginning of the program about how conservative I am. People will come in upset about something, and I want to have them held in contempt. And the judge is going to throw the book at them, right? And a lot of times my answer is, I don't know. What you're telling me, I don't think it's enough. Or, they may bring in a lot. And I say, oh, yeah, the judge I don't think is going to be happy about this. We're going to ask for contempt, and we're going to ask for these punishments to be put in place. But, I've seen it a lot, and we don't file it unless we really think we're going to get it. And sometimes we don't, but I would say the vast majority of the time we do, because we this is how we do it in our firm. We're just we want to make very sure of what we're filing. I mean, we just want to make sure we have grounds for what we're wanting to ask for.
Yeah. Got a long one from you. Going to read it from the phone here.
Now, Eric, before you go on to that one, let me qualify that. Understand that being held in contempt could mean that the judge says, I'm finding you in contempt and I don't want you to do that anymore. And that's all the punishment they get. I mean, understand that there's not always some huge substantial punishment that comes with the contempt. Right. So that's something to keep in mind.
Definitely. I'm not so sure what you're talking about here, Todd, but I want to answer your question. He said, what about teaching a child to blatantly lie?
Well, if you're talking about if the judge is going to want to know that, absolutely. Todd, this goes to this evidence issue too of trying to prove it. You know, are you going to have the child come in and testify that mom came in and told me to say X, Y, and Z, and that's what I did, and that's why I did it? Or who's teaching, who's doing? Usually we're talking about a parent is the one that's coaching or teaching the child to do that. If you're asking if it's a serious problem that the judge needs to know about, absolutely. But that can be a house of cards sometimes trying to prove that in the actual hearing.
Yeah. Michael Watkinson said, okay, I have court on Thursday with a temporary order in place. Her mother has violated said order 20 different times since September and completely alienated me and brainwashed my daughter. Now my child is telling me all kinds of things that no 11-year-old child should be saying. Your wife needs to die, etc. I documented everything and sent to my lawyer, but at this point, I'm so unsure about what is going to happen that I'm legitimately afraid to go. They moved out of their apartment and into a motel because I knew their address. They didn't allow me to have visits in December and refuses to co-parent. What can I do?
So if this is the final hearing, you know, all you can do, Michael, is present all of that evidence. You need to just present everything. You've got a temporary order in place. If she's violated it 20 times, you need to go through each one of the 20 times. Your attorney needs to go through all of those and show the judge, look, this is a problem. This was not a slip up. This was not a one-off. This is a pattern. And judge, unless you do something about it, unless you come down on this parent, it's just going to continue. So we need some relief with how mom is acting. I don't know if you have an ad litem involved or not, but definitely if the parent is telling the child these things or doing whatever to make this child have negative thoughts about your wife, that needs to be addressed. The ad litem needs to deal with that, or you're going to have the child come in and testify about it. You know, you've documented everything and it's been sent to your lawyer. If court's on Thursday, you should be meeting with your lawyer in the next couple of days to kind of go over that, or at least talking about it. And you need to, especially if you're a little unsure about things, says you're legitimately afraid to go, you definitely want to be ready for that, for going to court. So you probably need to talk to your attorney pretty quickly and get on the same page.
Weekend NG, if I messed that up, I'm sorry. Said, what happens if ex-spouse is pro se and kept on filing motions? 3 DVs and 3 ex parte in a month, all denied.
Well, like we were talking about earlier, that judges get upset with attorneys that keep filing stuff or not following the evidence rules over and over. They get very frustrated with that. They get frustrated with pro se clients too. And I can tell you that your ex is digging a hole with that judge. And you know, if you've been to court or you're going to court, you will notice the judge when they open court, they'll announce your case, they'll say the case number, and the next thing they almost always do, you see them reach over and they grab the case file and they'll start flipping through it. Sometimes some judges will do it on the stand while everybody's waiting just to kind of catch themselves up. Some do it before court. If they go through and start reading all that stuff, they're going to think, this is that person that kept filing all that stuff that I kept having to spend my time denying because it didn't have the proper this or the proper that, or there was insufficient evidence, whatever it was. The judge is not going to have a very good feeling about that litigant. So as far as what happens, if something's being filed, the court will take action on it, But if you ever get to a point where you're actually having a substantive hearing, the judge is not going to be very happy with that person. I can tell you that.
Yeah. Man, this one right here kind of puts a fire under my tail. Jim Wagner said, "Who do I talk to about pressing charges for putting a hidden recording device in a diaper bag? She gave it to the guardian ad litem as well. She wasn't able to use the recording as evidence, but she has thrown every false allegation as there can be at me. I'd like for her to stop."
Eric, you may not believe this. I had this exact thing happen in a case several months ago.
I believe it.
We had an infant. Well, this is the first time I'd ever had another parent, now trying to video, take pictures, that kind of stuff, maybe try to record phone calls and all that. That stuff happens. I mean, we see, recording visitation exchanges and all that. But this person hid a microphone in the bottom of the baby bag, hidden up in there to where it couldn't be found. And my client found it. And, I can't go much into more to that because this case is ongoing, but that has actually happened. And you need to turn it over to the police and press charges. And my client went and talked to the police, and they did. And it turned out it was one of the grandparents that did it. We talked about grandparents being alienators. Grandparents were involved in this one, and the grandmother got arrested. And, I don't know how that's all going to shake out, but that's what you need. You also need to let your attorney know if you've got a GAL, so you must have an ongoing custody case. You are definitely going to want to bring that up in court, and I can guarantee you my client and I will be bringing it up in his case.
Brother, I'm so sorry you're going through that, Jim. But please keep in touch with us and let us know how that goes. Aaron,
Jim, don't let it go. The prosecutor and the police work for you. You pay your taxes. That's what they're there for. Talk to them about prosecuting. Get your attorney involved to talk to the prosecutor and say, hey, this is not normal run-of-the-mill thing. We need something done about this. And despite what the prosecutor does, whether they press charges or not, bring it up in your custody case. I can't imagine a judge is just going to brush that off. Most judges I know would be extremely pissed that happened.
Yeah. Aaron is asking about a lawyer named Leon Koziel. Do you know who that is, Kevin?
I don't think so.
I don't either. If you can write me and let me know a little bit about that situation, maybe we can get you some insight on that. But I don't think either of us are going to be mindful of what went on there. Dewan Akobe Mitchell said, "What should you do if your child is legally kidnapped? Meaning I was never given the opportunity to get my son. His mother went to prison and I was in Iraq during this time. And I now pay child support to a child I've never seen." Doggone it, man.
Well, if you're back, Dewan, I may need a little more information, but if you're back, you need to try to get custody. If you're paying child support, then that means child support enforcement has declared paternity, that you're the father, and you've got just as much legal rights as mom does. And you said she went to prison. I don't know if she's out, but you need to be pushing that and either trying to get custody. If you can, you may still be deployed. I don't know, but you've got just as much rights to ask for that child as she does. And if all this has happened and she's just not fit, you need to go back to court.
Yeah. He said right now the grandmother has legal custody of him.
Well, then there's some kind of guardianship that's happened. So your rights now, grandmother has an order right now, so that trumps everything else. But as far as legal rights to the child, and parents always take precedence over grandparents. So you need to talk to an attorney and see if you can get custody.
Yeah. Chris Dodson said, Kevin, you got to watch Cobra Kai.
I think that's the Chris that I know. Maybe a buddy of mine. And I know I've been hearing that from a lot of people. So if I can get my wife on board, we'll watch it.
All right. NG said, how difficult to get move away order with young kids?
It depends. If you have full custody, I can tell you about Arkansas. the law is very much in your favor that you will be able to move if you are the full custodian. I've never really liked that law. I don't know that promotes really trying to keep families cohesive, but the law is very much in your favor in Arkansas if you have custodial rights to be able to move.
Yeah. Where was it? Scott Maximin said, will there ever come a time that the person that is getting child support has to show proof that the support is going to the child?
Scott, I may have some good news for you. I think every state's like this. I don't know what state you're in. Arkansas has a statute that says every quarter you can ask the payee parent, the person that's receiving the child support, to provide an accounting of what they're spending the money on. Does that mean their child support will change or not? I don't know about that. I've never had to go that far and ask for an accounting, but check your state where you are. There may be a statute. Now, you usually have to send the request certified mail, but you can ask for a quarterly accounting of what the child support's going to.
Yeah. Dan Fair on Facebook said, what can you do if someone owes $7,000 and only pays once in a while? I have custody of my son and my ex-wife owes child support to me now. However, she was ordered to pay in 2020 and hasn't paid $700. I'm guessing he's saying has paid $700 total. A guy does that, he is in serious trouble. A woman does that, she is okay, and I live in New Hampshire.
Every state is different as to how seriously they handle child support arrearages like that. $7,000 is well into the felony level in Arkansas. And you're right. A lot of guys would be getting arrested for that. It's always a catch-22. Obviously, if you arrest them, put them in jail, they're going to either lose a job or not be able to work. And you're definitely not going to get any child support. Regardless, if she's working, there should be some kind of wage withholding order in place to automatically take that money out of her check before she gets it. So I don't know if you can hire an attorney. It would probably be worth at least a consult fee to go consult with an attorney in New Hampshire. Or if you've used child support enforcement before, go back to them because she needs to be paying that.
Yeah. Brandon, I think your question popped out. He said, question, if you're 1 red cent behind in child support for the year, you're not supposed to claim your kids on your taxes at the end of the year. And then it says, I think it might have ran out, but I haven't heard of that one. If you're behind on your child support.
Yeah.
I haven't heard of that one, but brother, if that cut off, get it down there to me and we'll get that one back up there. Claire Bowles said, my ex kept my kids for over a month. And even though I had every other weekends, my lawyer didn't do a damn thing about it. I had to yell at her, I want to see my kids. Why didn't she take immediate action as soon as the first missed weekend?
Claire, not really sure what to tell you on that. Every case is different as to when we decide to go back to court. If you had an order in place, it looks like you're wanting to go back for contempt. If somebody missed a weekend and came and talked to us, we just have to discuss that and figure out if it was egregious enough. Anytime that you lose, obviously, is serious. It's important. But what a judge is going to do about it is a different matter. And we're always weighing, at least in our firm we do, we're always weighing. We know it's going to be a decent sized retainer that you're going to have to pay us to hire us. We don't want you, I always use the phrase, I don't want you to pay me a lot of money and then I don't get you anything. It doesn't help you. And it leaves a client with a very bad taste in their mouth. So we want to make sure when we go back to court that we're really going to get you some relief. And if the judge just says, well, don't do that again, a lot of clients feel very unsatisfied with that. So I hear what you're saying. And when that pattern starts to develop of losing your weekends, then yeah, you definitely need to be going back to court. I don't know why the attorney handled it that way. I can't answer that.
Dimitri Schvetz said, all the judges in my district are recusing themselves except the one judge I am currently seeing, even though I sued the judge as well. Can I transfer jurisdiction of the custody case based on bias factors? The ex-wife also did not have 6-month residency when she filed in the beginning. It took 3 years to go through the divorce process to find this info out.
There's a lot there. I'm not sure why the judges are recusing. It looks like you sued one of them, so that may be one of the issues. Yes, you can always try to transfer jurisdiction. Usually they try to transfer it to another judge within the jurisdiction if there's some kind of bias. But you've got to show bias. And we've talked about how hard it is to get a judge to recuse for bias. Usually when a judge recuses, it's because they either represented one of the parties in the past or did business with them, or there's some other relationship there that makes them biased one way or the other. The 6-month residency issue, it sounds like that happened 3 years ago. You may be beyond the point of doing anything about it. Now, there's something that may be what we call a subject matter jurisdiction issue, which can always be raised. So if that is a subject matter problem in your state, the 6-month residency requirement, you may be able to do something about that. You need to talk to an attorney in your state and find out and make sure you're very clear with them about this 6-month issue, and then bring that up. And what he's talking about, so everyone understands, you have to live in a state a certain amount of time before you can file for divorce. Eric lives in Georgia. I can't go to Georgia tomorrow and file for divorce. I mean, you have to live in that state for a certain amount of time. Every state is different. In Arkansas, it's 60 days. Some states you have to live there for 6 months. So what he's saying is that his ex-wife, he's discovering, did not live in the state for 6 months before she filed. That can cause a problem. And that's many times what we call a subject matter jurisdiction thing, which could mean that the court never had jurisdiction to do what it did. So that's what he's talking about.
Gotcha. Gonna read this one from the cell phone, little long one. Said Michael Nasarino, any ideas about suits? X has an OP that she lied to get. It states that I have to stay away from our residence. It does not state distance. I brought our 11-year-old breakfast while he was homesick, and she left him for over 7 hours. I delivered from my car window from my neighbor's driveway. It is on Ring doorbell camera. She found out, and that night my visitation started at 4 p.m. I was arrested at my apartment in front of my kids. I asked for a supervisor. An officer threatened to call CPS on me. He told my kids, 11 and 19, that dad needs a psych eval. What was I in violation of? She never said that she left minor children home alone. Thank you, gentlemen.
Well, I know, Michael, it feels like because she's leaving the kids at home that justified you being there. And I'm not sure if it was just coincidence you were there while the children were alone, but you've got to follow those orders of protection. You're asking what you did wrong. My guess is that you violated the terms of that order of protection. You're ordered to stay away from the house. There's usually a radius. It'll say within 100 yards or 150 yards or 200 yards or whatever, and you're supposed to stay out of that area. His says that does not state distance. You might be able to beat it on that, but I think a judge is going to think you shouldn't have been at that house. I know you didn't go in. Sounds like the child came out to the car window at the neighbor's house, but it depends on the jurisdiction you're in. But that a lot of judges are going to have a problem with that. They issue an order of protection for a reason, and they don't want you going around the areas that they've stated you're not supposed to go into. At the same time, if there's no distance requirement on there and you want to get an attorney and fight it, you may technically not have violated it. So that's something you want to talk with an attorney about, a criminal attorney.
Yeah. I think we got this question coming in from an Oklahoman. Seems like you got a shot being taken at you. Chris Dodson said, is it illegal to turn your child from an Arkansas Razorback to an OU Sooner fan? Asking for a friend, Boomer Sooner.
Chris, it's not illegal, but I'm working on it, not only to make it a state law, but a federal law that is illegal. That is in borderline abuse. It's sad when that happens. And Chris, if you're doing that, that's very disappointing.
All right. We'll try to get some legislation passed on that one. Jim Wagner said, "What do I do if the police turn me away?"
I think he had a previous question about custodial interference.
Did and I got to go back through all.
Jim, if that was the custodial interference, I mean, they're supposed to at least let you file a police report. I mean, they'll almost always let you do that, or an incident report. Oh, that's on the hidden recording device.
Yeah.
I don't see how they're not going to let you file a report. I mean, go down there and try it. If they turn you away, I mean, I think that's terrible. But anyway, you need. To me, I would be upset enough. I think you need to give it a shot to try to have the police handle it, and then definitely take it to your attorney.
Yeah.
Lex, make sure the ad litem knows too.
Yeah. Lex on YouTube said, "My original order was vacated by the APP.
That's the appellate court. Yeah.
Appellate court. My bad. Long day. The subsequent order was nullified by the judge filing it before the remitter. Plan to file new petition. Am I on the right track?"
By the judge filing before the remitter. Plan to file a new petition. I think so. Subsequent order was nullified by the judge filing it. So I think he's saying the other judge nullified it before the Court of Appeals did. Lex, without more, yes, I think you're in the boat of filing a new petition. You may want to really read that appellate court decision, though, or have an attorney read it and help you with it, because I don't know what the effect of that was. It may have just said you should get a new hearing. So then whatever you were asking for before, you wouldn't have to necessarily file a new petition. You're just going back to court on it. But probably need to talk to an attorney about that, at least to have a consult about it.
Dan Fair said, "Also, sorry for the next question. Dan, don't be sorry. That's what this is for, brother." He said, "During my 9-year battle, my son has been shot with a paintball gun at 3 years old when he was visiting his mother's boyfriend in Massachusetts. And because she refused help from the EMTs and took my son out of Massachusetts and back to New Hampshire, Massachusetts police said they couldn't do anything about it. My ex remarried and her new husband has punched my son, choked my son, and let go as unfounded. And then what got me custody was he ditched my son and his sister, not my daughter, in the middle of a highway and was arrested on 2 counts of child endangerment, and he admitted to it with witnesses of what happened. However, he was only charged with 1 count of disorderly conduct. Does that sound right, or could I sue civilly?"
That doesn't sound like he was charged with enough, but remember what we talk about. Prosecutors are always trying to figure out what they can prove beyond a reasonable doubt in court. And so that's why you will see, especially on some of these high profile cases, someone will get killed or whatever, and then you get them see them be charged with manslaughter or second degree murder. And people will think, why is that? Why are they not charging them with capital murder or first degree murder? Well, there's usually a lot of facts involved in the case that either we don't know or that the prosecutor is trying to figure out how much proof do we have on that particular element. When you have a crime, you have all these different elements that the prosecutor has to prove, and they have each one. You can't have a whole bunch of evidence on 3 out of the 4 and then nothing on the 4th one. If you have nothing on the 4th one, you lose. So each one of those elements of a crime, you've got to prove. And so prosecutors really go through that, and they want to make sure what they charge a defendant with, that they can make it stick and that they can prove it beyond a reasonable doubt. That's what they're always thinking about. So, it does sound like this guy was undercharged for what happened, but the prosecutor might be able to sit here and explain to us exactly why they made that decision. It's just, I'm glad. It sounds like you got custody. I'm glad of that. It sounded like the kids definitely needed to be out of that environment. That was terrible. I think he had another part of his question I can't see there.
Let me go back up. He said, "Does that sound right, or could he sue civilly?"
Oh, the civil thing. Yeah, I think absolutely. You'd sue on behalf of your son. Yeah, I think it's just like any other injury case, a car wreck, or any other negligent injury or this may even be an intentional, what we call an intentional tort, like a battery. You could talk, you could definitely sue civilly for that. It's worth having a consult with a civil litigation attorney.
Yeah. Chris Gardner said, my kid's 11 years old and constantly talks about wanting to live with me. He tells me how he's treated at his mom's, etc. His mom in our last case tried to take time from me. The judge didn't agree and wanted a guardian ad litem appointed, but she soon dropped the case when she realized she had to pay her portion and I was fully ready. Now she wants a truce and promised our child that he could live with me after the summer. Well, the summer's long past and she keeps telling him no and getting angry at him when he asks to stay the night. So my main question is, when can he talk to someone that will listen to him? And he is in Washington State.
Chris, he's old enough now. He's 11 years old. He's old enough now to talk to someone like an ad litem. The issue you're going to have is change in circumstances. I'm not sure what the law is in the state of Washington, but in a lot of states, this is called the child's preference, where the child's preference as to where they want to live, at mom's or at dad's. In most states, that's not enough of a change in circumstances to change custody. So you need to talk to an attorney where you are and see if you have enough evidence to get custody changed. I would want to know things like how often, is the child having to get counseling? How often is he complaining about mom and her behavior, and what is she doing? Have teachers noticed mom's behavior? Have others that are you may have mutual friends with mom that will talk to you and talk about how she's acted. If mom is creating an oppressive, bad environment at home, that can really be emotionally and psychologically damaging to a child, upsetting to a child, and not a good environment. If those things start to fall in place, with also the child wanting to come live with you, now you may have a viable custody case.
Michelle Early Manor said, if the mother has contempted a custody order, but there was also an ex parte order where she was not given temporary custody, but the judge told her to turn the child over, does this make the mother in contempt for both the custody order and the ex parte order? The judge told her if she contempted, she would have a bad day, and she did the very same weekend and 5 weeks after.
Your question there is, does this make the mother in contempt for both? Yes. If both those orders are in place and she violated them, you can definitely be in contempt with more than one order. And that is, I hate this is going on, Michelle, but that is a very good sign for your case. And this is the kind of stuff I was talking about when I said the judge goes through the file and kind of gets a little bit of a history before you start your hearing. When a judge says something like that, you're going to have a very bad day if you're back in front of me again on a contempt issue. You're going to want to bring that up, and I've done it before in cross-examination with a parent, and just asked them, say, do you remember when we were here in May of 2019, and you remember this judge sitting right here told you were going to have a really bad day if you came back to court in contempt again? Yes, I remember that, and whatever. You want to bring that up. And you want to remind that judge of what happened before, and that, judge, and a lot of times we've talked about on contempt, you've got to lay groundwork, sometimes over time, months, years. You want to remind that judge, look, we've been here before, judge. She will not listen to you. He won't listen to you. You need to do something about it. So it sounds like she's in contempt, and it's time to bring all that up.
Yeah. Looks like this is going to be the last one for the night. Comes from Mr. Isaac Johnson. He said, do you ever take a defense attorney approach to clients you feel are expecting too much? Do you try to reason with them or simply represent their interests?
Isaac, that is an excellent question. And we are always on that, I don't want to say fence, but I'm always trying to really zealously represent my client and also keep them from getting way too far off the road. And there are a lot of times when I talk with a client and say, look, you don't do this every day. I do. You're paying me for my advice, not to be your friend, and say, yes, that's great to you all day long. And I say, and from that background, here's what I need to tell you. Our case is not looking good. Those things you did in the summer, or the visitation thing, though, that text you sent, just whatever it is, I try to reason with them by showing them the evidence that's going to come out in front of the judge and let them know we either need to settle or we need to look at we need to ask for something differently, or this is going to be a real problem. It's always the client's decision whether they want to go to court or not, but they're not going to go in blind. If I have those thoughts, they're going to know about it. And so it's not, I wouldn't really say taking a defense attorney approach, but yeah, if I think they're asking for too much, I'll tell them. A lot of clients come in and they immediately want supervised visitation. And when I ask them why, many times they don't have enough reasons for supervised visitation. That's a big request we get. And I tell them, a judge takes parental rights very seriously, and they're only going to make a parent have to go to supervised visitation if there's a real reason. Now, if there's been abuse, harm to the child, the parent is, an alcoholic or having drug issues and really putting the child in a dangerous situation, or has recently, and the child almost got harmed or did get harmed, then yeah, you're going to be looking at supervised visitation. But just because you may have had some disagreements with the other parent or whatever, that's not always going to be enough. But yeah, we always try to reason with our clients and let them know the handwriting on the wall and what it's going to look like. And, sometimes they listen and we're able to get a case settled or go a different route and get some different relief to help them. Sometimes they say, I don't care, I want to go to court. And, I did my job. I explained to them the problems and the risks. And if they want to take that chance, it's up to them.
Yeah. All right, guys, it looks like that is it for the end of the night. Appreciate all the questions. Kevin, if anybody wanted to reach out to you, maybe for a consultation, needed your services, or maybe they want to find some more resources behind parental alienation and study up on what's going on, where can they find you?
You can go to our website. It's www.kevinhickeylaw.com. That's all one word, kevinhickeylaw.com. We have a lot of information on there about parental alienation, CPS, divorce, custody. A lot of free information that you can go and read articles we've got and different information. Excuse me. My office is in Arkansas. We have 3 offices now. We're in Fort Smith, we're in Northwest Arkansas, and then we have a new office in Russellville, Arkansas. You can call us at 479-434-2414. That's 479-434-2414. If you will tell the receptionist that you heard about us on Dad Talk Today, we will. You can have a free initial consultation. We won't charge you for that. And I'd be remiss if I didn't say that we handle high conflict custody cases all over the country. So any state that you're in, we can become licensed in that state for your particular case. We work alongside your local attorney. So any high conflict custody cases, that's custody cases involving parental alienation or sexual abuse allegations, CPS has gotten involved, anything along those lines, we come in and work with your local attorney, and we'll take you all the way through trial.
There you go. Any New Year's resolutions, Kevin?
Man, I don't know. I can't think of any. Maybe be healthier. I don't know.
Yeah, I'm probably
eat more green beans.
Yeah. All right, guys. Well, Happy New Year to every one of you. We will be back in 2 weeks. Until then, Kevin, appreciate it, my man.
See you guys later next time.
All right. Hey, everybody. Eric Carroll here. Thank you for tuning in to another exciting episode of Dad Talk Today. While we fight for you, we would ask for you to please help fight for us. Like, subscribe to our channel, and ring that bell so you get notifications every time we go live. There's also Super Chats, patreon.com/dadtalktoday, and other ways you can support our channel. Thank you for being here, and we will see you next time.